Hello, everybody. Hello, Nana Laura. Hello, C-Rex. How are you guys doing tonight? Nah, you don't need that. I'm here, and I was here on time. You've been waiting for hours, though, so that it doesn't count. Hi, Ava. You count. Ava counts. Ava counts 1, 2, and 3. Because that's how many treats she gets. Well, that's a twofer. That's a twofer. Oh, my goodness. And then she knocks stuff over. Of course. Hello, Blue Sweetie. Hello. Oh, sorry, the chat jumped. Hello, Angela, dear. How you doing, sweetie? I'm so happy you made it. Yes. Lots of love. You see a Billy butt. Yes. He's not even going to turn around. Smack his little fluffy butt. Hello, Spider-Man, honey. Would you guys believe it? I forgot my coffee in the kitchen. So when the case starts, I have to go get my coffee. This night will not go well without it. Hello, Eileen E. Carlin. I'm sorry. I've had that happen to me before. Are you okay there? You should go get a drink of water. Oh, I've got a bunch of them. I have a bunch of them. It's a whole bunch of crazy stuff in Michigan. So we've got a guy who forgets what clothes are. And we get to listen to the swear to, which is where the officers go in front of the judge and, get the probable cause to go forward on the case and everything. And then we get to see the arraignment. So, and then there's an FTC in there of a gal who used her vehicle as a deadly weapon. And let's see, we've got a boyfriend-girlfriend brawl outside of a bar. And that, it goes as well as you would expect. It goes Michigan. Speaking of which, I want my coffee. So let's all go to Michigan. Oh my goodness. Can you chew any louder? Oh, you're eating the cat food. That's why. The cat food she knocked over. Not on purpose or anything.
We go to the next one. Calling case, prosecutor order number 25-2503004 to swear to in the matter of Michael Ralph Mucerino, Mucerino. Detective, you're already under oath. Just state your name and the facts in this matter.
Detective Berengo with the Royal Oak Police Department. The facts of this case are summarized under Royal Oak Police Report number 25-7655 and are summarized as follows. On March 14, 2025, at approximately 10:30 a.m., officers were dispatched to a coffee shop at 25070 Woodward for felonious assault that had just occurred. Ultimately, officers were able to locate and arrest Michael Mucerino and review video from inside the coffee shop. What happened was there was another patron that was listening to music louder than what Michael wished. He asked him to turn it down. The gentleman did turn it down. Michael was not satisfied that it was turned down enough, accused this individual of being a West Coast gang member because he was listening to Tupac, and then pulled a 11 to 12-inch butcher knife from his pocket or waistband and began approaching this individual. It should be noted that it was a full establishment with 20 additional people, I believe, in the area at different tables. The victim grabbed a bar stool chair to hold up to protect himself from the advancing Michael, who had the knife in his hand. There was a standoff of approximately 20 seconds or so where he had the knife out, threatening the individual before he finally left. He got into his car, drove away. Officers were able to find his vehicle, pull him over. He approached officers. They asked about the knife. He pulled it from his waistband and ultimately threw it on the ground and was taken into custody. I would like to note that the prosecutor is also reviewing this on Monday with a supervisor to see if an additional charge of ethnic intimidation is appropriate, as Michael made numerous statements that make it appear that this individual is signaled out for his ethnicity, believing that he was a West Coast gang member. So with that, the warrant is before you at this point for just the felonious assault with a knife.
Okay, the court finds thank you for that. The court finds the alleged crime was committed. Probable cause to believe the defendant committed said offense. The court will sign and issue the complaint and warrant in this matter. Any CCH information?
Yeah, he's got a pretty lengthy CCH. I'm going to ask for a $250,000 no 10% bond. One, because of the significant risk to the public. He was set off by a guy listening to music and pulled a knife on him with numerous people around. He has no ties to the community. He actually has a New Jersey address and said that he's just passing through to San Francisco so that he can infiltrate the West Coast gangs out there in order to better understand them and protect his people. As far as his criminal history, he has a CCH, I believe, out of Delaware and New Jersey. He has an assault charge from 2022, a weapons charge at a school in 1999 in which he received diversion. He's got a trespass charge, B&E, assault, MDOP and theft, tampering, and 2 drug charges, with the most recent one being 2020. So I'll ask for a $250,000 no 10% and GPS tether upon release.
Okay, thank you, Detective. On that, the court has indicated the court finds the alleged crime was committed. As I stated, probable cause to believe the defendant committed it. Court will sign and issue the complaint warrant in this matter.
See, it's 3 of them, correct?
Yes, sir.
Michael,
I'm sorry.
here's your attorney. To represent for the arraignment this morning.
This guy, y'all. This is the guy that's going to infiltrate the West Coast gangs for his people.
We got arraignment. Michael, can I just start my word for 1 second before the proceedings? I just want to ask for one thing. Your Honor.
Okay, thank you.
Your Honor.
Okay, calling case prosecute order number 25-03004 in the matter of Mike Ralph Mucerino, Mucerino. Counsel appearance for the record, please.
Attorney Monica Sanford on behalf of Mr. Mercerino.
Sir, at the jail, would you please state your full name for the record?
Michael Ralph Mucerino.
Thank you, sir. Counsel, how would you like to proceed in this matter?
Waive formal reading, client stands mute.
Waive formal reading. I indicate that your client stands mute. I see your client is requesting court-appointed counsel in this matter. Court-appointed counsel has also been granted, so you will have an attorney representing you at your next court appearance. Counsel, you can address the Honor if you like.
Your Honor, it's my understanding that Mr. Mussolino was traveling from New Jersey to a new destination, has been here maybe a few weeks. I know that he would like a person bond at this time. He is not employed, but he indicates he will participate and come for all future court proceedings.
Okay, thank you, counsel. Sir, where are you living?
New Jersey, Your Honor.
Okay, you're no longer living in Wisconsin, right?
I'm not, Your Honor.
How long have you been living in New Jersey?
I was back in New Jersey for a period of again, Your Honor, it's hard to say.
It's okay. Okay, it's not a problem.
I just, Your Honor,
No.
if I may, I can.
No, I
Mr.
don't know if you may. I don't want you to say anything. Go ahead, counsel. I'll let you talk to your client.
Mr. Mercerino, I don't want you to say anything else. Remember, we talked about this. I just don't want you to say anything else. Let the magistrate move forward with setting your bond, okay?
Yeah, I understand.
Okay. Okay, sir. So listen up. So I'm going to cover a few matters before I get to your actual bond amount here. I just want you to know you do have some other court dates coming up. Your next court date is your probable cause conference, which is scheduled for March the 24th of 2025 at 9 a.m. And then you'll have an exam after that, which is your next court date after the probable cause conference. Your exam is going to be March the 31st of 2025 at 9 o'clock a.m. This matter will be heard in the 44th District Court here in Royal Oak, Michigan. Like I've indicated, I've granted court-appointed counsel for you. You will not have any direct or indirect contact with the complaining witness in this matter, who appears to be a stranger, Andre Farr Jr. You will not return to the premises known as the Royal Oak Roast Coffee Shop at 25070 Woodward Avenue in Royal Oak, Michigan. You will not assault, beat, molest, or in any way verbally harass, intimidate, or threaten any witnesses. Personally appear for all court appearances. You do not leave the state of Michigan without permission of this court. You immediately notify the court in writing of any change of address or phone number. You shall not possess any firearms or other dangerous weapons. You will refrain from using alcohol, any form of THC, marijuana, illegal drugs, or abusing any medication. The court is not requiring that you test at this time for those matters. Pick up no new criminal offenses while you're out on bond. This matter, do you understand what I've read off to you, your bond conditions, sir?
Your Honor,
I know your attorney is concerned, so I'm gonna try to do this so that you don't say anything that's detrimental to you. First of all, before I get to your bond amount, I want to know if you understand what I've read off to you already.
Can I speak to I just need 2 seconds to speak to my attorney. Just please let me speak to my attorney in private for 1 second, please.
Okay, let me just say this. I don't have a problem with you speaking to your attorney, but what I need you to answer the question though. Do you understand what I read off to you? I'm gonna have to read that to you again if you don't understand it, and then we'll go from there. Do you understand what I read off to you, your bond conditions? I basically say that again.
No, all I would ask is that I can relocate to a safer place.
Well, we can get to your dispute. I understand that. We can talk about those things. I just need to know if you heard me.
I did, Your Honor, but I'm not asking you if you agree with me, sir. I'm just asking if you understand what I read. I'm sorry. Give me 1 second, Your Honor. This thing you want to get rid of that. That's not. I would ask, but you understand what he's asking. Yeah, I understand what he's asking, but
You understand, but you have a statement you'd like to make about it or question about it.
all right. Yes, I'm sorry, Your Honor. Are you there?
Do you understand your bond conditions, sir?
Yes, I understand.
Okay. Hold on 1 sec. the court's gonna, you do have an attorney here. You will have an attorney at your next hearing. The allegations in this matter are of a dangerous nature. They're an assault of nature. It appears to be the matter from the allegations unprovoked. Bond will be in the amount of $300,000, cash surety, no 10%. Counsel, do you have anything further?
Your Honor, while I understand that these are a serious nature, and I understand that the public safety has to be protected, 300,000 cash surety, no 10% is it an extreme? I think excessive. I think that a bond be set to accomplish that without it being $300,000. The reality of it is a $50,000 cash surety 10% is going to stop him from going anywhere anyway. But I think 300,000 cash surety is a bit excessive, Your Honor.
Okay, thank you for that, counsel. The court's main concern is that your client has an unstable residence, from what I can tell. The file says he lives in Wisconsin. He says he lives, I think, in New Jersey. I don't know where he lives. I don't know what his financial condition is. I can only go by what I have here in front of me as to the allegations of an unprovoked assault with a dangerous weapon. And based upon that, I want to assure the public of the safety of the public in general, being that this matter appears to be somewhat of a matter of a total stranger, unprovoked matter. That gives the court serious concern. I'm not sure what's going on. Bond will remain at 300,000 cash surety, no 10%. So I'm all set, Detective. All right, and sir, you'll get a chance. Good luck to you. And you'll get a chance to speak with your attorney before your next court date, which I've indicated already is on the 24th of March.
We're back on Dabney.
This is case 2502019 LT Copper Tree Apartments versus Delano Dabney. Delano Dabney, you spoke with Ms. Cohen. Did you find her to be open and honest with you?
Yes.
And did you understand all the rights in the rights presentation?
Yes.
Ms. Cohen, the terms and conditions?
We don't have any because he said he applied for financial assistance, but I don't have any record of it. And I don't know that he submitted anything to the court.
No, there was nothing submitted to the court. Let me just double check. Last time we were here, let's see. Sir, did you file a Form DC 539?
I'm not sure what the letters mean, but after the first court date, you had given us information on how to file, and I went and I did that for the emergency relief for rent. So I did file that, and it is pending, but I had nothing to submit.
Okay,
to the court.
so I have the form here. Are you raise your right hand? You solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
And you stated that you filed an application for financial assistance based on the information that I gave you at the presentation of rights?
Yes.
And with which agency did you file an application?
I went to the DHS office.
All right, so the Michigan Department of Health and Human Services?
Yes. And Taylor.
I have the form right here. Would you like to give me permission and consent on the record to sign your name to the form so that I could put that in your court file?
Yes.
Your Honor, I would object. He is supposed to do that within the first 5 days. The court was pretty clear. If he doesn't do it, he's not entitled to the adjournment. I mean, there's, thousands of dollars owed, and he was supposed to do that within 5 days of February 27th.
All right, well, they had to file the application if one has been made within 5 days of the presentation. That's the one thing that's the one glitch about the whole thing is that they require me and I'm required to tell them how to file an application and where to file an application. So if they've already filed an application, they have to give that to me 5 days from the date of the initial hearing. That's if they've already filed one, but if they don't file one until after that fact, the court rule doesn't, it kind of leaves it in limbo and just leaves it up to me to determine whether or not we should go ahead. It doesn't say that there's anything. So I just treat it as, I'm going to go ahead and give you the adjournment to see if it gets done, because that's what the court rule does call for. It doesn't say anything about people who file after your first hearing. It just says that by the date of the first hearing, if you have an application pending, then you have to give within 5 days of that date. That's why I always take it on the record right there, that date. But that says they have 5 days after that date if they have one that's pending. The problem is a lot of people haven't even heard about it until that first date in the first place. So I'm going to adjourn this to.
Doesn't it come in the court papers?
What do you mean?
Well, when they get sent all the papers from the court, I believe that information is in there.
It does, but I didn't write the court rule. The court rule says that if you have an application that's pending at the time of the first hearing, you have 5 days to get that the DC 539 into me. It doesn't say anything about people who file it after that first court date, because maybe some people are not literate. Maybe they don't read this stuff. I mean, all I'm saying is I physically, that's why I'm required to verbally state all of that. And I think that's why. So I'm just going to adjourn it. Your objection is duly noted. But overruled. I'm going to go ahead and adjourn this to the 26th. And that's going to be the last adjournment then, because that'll be the third time we've been here, but we'll see how it goes.
Her voice was so whiny that it drove me nuts. I can understand, making the objection, but then when it doesn't go your way, to continue to whine like a child is just obnoxious.
Both of you have a good rest of your day.
Yeah, you too. Thank you so much.
Thank you, Your Honor.
Have a good day. All right, Mr. Mudar.
Yes, Your Honor.
You had the opportunity to speak with Cordero Wright and Angelo Martinez, is that correct?
That is correct, Your Honor.
All righty. And was there any resolution in these matters?
Yes, Your Honor. We have a resolution on both.
All right, Mr. Martinez.
Hi.
Mr. Martinez. When you spoke with Mr. Murda, did you find him to be open and honest with you?
Yes, sir.
Mr. Wright, did you find Mr. Murda to be open and honest with you?
Yeah, he was open, but we had a little bit of discrepancy, and we couldn't kind of figure out why was that, but everything else he was explaining correctly.
All righty. And did both of you understand all of the presentation of rights that I gave last time?
Yes, sir.
Yeah.
All right, very good. Now, with regard to Fairlane Apartments versus Angelo and Latavia Warren and Angelo Martinez, was there a consent judgment, Mr. Murdo?
Yes, Your Honor. So we've got a consent judgment to Angelo Martinez. And Miss Warren is not currently present, so default to her, but with the same terms, of course, that Angelo Martinez is receiving on the consent.
All righty. And those terms and conditions are?
So we've got a rent to retain possession on this one in the amount of $3,316.28, court costs in the amount of $171, giving us our grand total $3,487.28. We're providing until March 31st of 2025 to either pay or vacate. And then in paragraph 10, we've got language that indicates that defendant indicates that he's made a payment of $1,902. The payment was made yesterday, and so it's not yet addressed on the above balance, but we're agreeing that to his indication that he did make that payment. And then we've got language that states if defendant pays the balance on or before March 31st of 2025, parties agree to stipulate to set aside this judgment and dismiss this case. Defendant must email plaintiff's counsel to confirm full payment. I have received permission from Mr. Martinez to add his signature to this resolution, and we have went over MCR 4.201J.
And Mr. Martinez, did you hear, understand, and agree to all those terms and conditions?
Yes, sir.
All right, that is granted with regard to the consent judgment and as to the default judgment under the same terms. And send that in via the portal or email.
Understood, Your Honor.
And as to Mr. Wright's matter, was there a consent judgment?
Yes, there is, Your Honor.
All right, and what's the terms and conditions?
So we've got a rent to retain possession in the amount of $5,325.87. We've got court costs in the amount of $171, giving us our grand total of $5,496.87. We've got, we're providing until March 31st of 2025 to either pay or vacate. And then we've got language in paragraph 10 that indicates if defendant pays or vacates on or before March 31st of 2025, parties agree to stipulate to set aside this judgment, dismiss this case. Defendant must email plaintiff's counsel to confirm full payment or having vacated. And then I've received permission from Mr. Wright to add his signature to this resolution, and we have one over MCR 4.201J.
All right, Mr. Wright, did you hear, understand, and agree to those terms and conditions?
I heard and understood things, but I don't had a lot of problems with this, but it kind of just seems like this was my only choice and only route to go. So this was the only thing that I could accept. So, but other than that, we had problems. It's just that it was just like he kind of told me, well, he was giving me this amount, and if I kind of went back to you to kind of ask you some questions about, they had a discrepancy about the money that he said I owed and the people and what they had gave me and the emails that they sent me. So it was just like, I'd rather take the 14 days. And basically he said, if I came back to you, I was only going to get 10. So that's the problem. Other than that, if I knew that
well, first off, that is correct. I can only give you the statutory 10 days. If he's going to extend it to the 31st, that's different. Secondly, if he's also including where if you get caught up or you move out, then they will go ahead and set aside the whole case so that it doesn't go on basically your credit history, I think is what's the most concerning thing there. And I can't add that. I can't add that kind of language. So it's just a matter of, are you agreeing with the consent judgment terms as they propose them, or are you not? That's all.
Well, I'm just trying to, I mean, see.
There's no just trying to, it's either yes or no. I can't give you any legal advice. So if you want to.
I mean, well, that case, I won't have no choice but to say yes. I mean, y'all go do whatever y'all want to anyway, whatever. It's basically, this is crazy. I mean, I guess I would try, not trying to legal advice. How would I go about trying to just correct the situation after this? Because things are not right. So I'm going to agree with it, but I just want to be done the right way. So I just want to be able to get somebody to help me out with what was going on.
Well, first off, there's not going to be, I don't know what you mean by, well, they're just going to do whatever you want to do anyway.
Meaning that they already listen, trying to see how can I go in the right way.
I said, listen, that means stop talking. What I'm going to do if we go to hearing is I'm going to look at the lease, see how much the rent is. And then you're going to show me receipts for rent that you've paid. They're going to testify about which dates they were paid on and which dates they were not paid on and how much the balance is that they say you owe. And then I'm going to ask you under oath, and you're going to be able to say which dates you paid on, show me your receipts for those payments. And then it's just math. It's just me adding up rent payment, minus payment, and here's how much you still owe. It's just simple math. There's not anybody doing anything the way they want to do it or whatever. It's called renting. It's like going to a restaurant. You buy, I don't know, you buy a dinner, and then they serve you a dinner on the plate, and then you pay them the money, and then you eat the dinner. It's just a service. That's all it is. And so this isn't that hard of a case to figure out. It's either did you pay the rent or did you not pay the rent? How much is the rent? That's easy. It's all math. It's just all math.
I know
As
the
long as
math.
I have, as long as I have receipts for everything to look at, then it shouldn't be that big of a deal. So if you want to have a hearing, we'll have a hearing. I have no problem with that. But what I'm saying is I just need to know that if you're gonna, if you want to take a deal, people take deals for all kinds of reasons. And I don't need to know what the reason is. I don't need to know what your reasoning is behind it. I just need to know that you're voluntarily choosing to go that route. That's all. That's all I need to know. So are you voluntarily choosing to take the option that they offered you? Yes or no?
Well, if we can go to the hearing thing, I mean, I'd rather be right about something than just wrong. So.
Okay, so you want to have the hearing? Okay, not a problem. So we'll set this up. We'll set this up for a hearing. Let's see. What is my?
I'd rather be right about something than just wrong. I think Judge Slavin needs a t-shirt that says that.
What does Friday look like?
Friday we have a lot. We have no informals, but we have a big.
No informals? Right. What about, is it morning and afternoon?
We just have morning, so.
You want to know what? I'm just going to leave and get out the property. This is just something that I'll just take a loss on and have to learn.
Well, I was gonna set the hearing for this Friday afternoon.
Yeah, it don't matter. There's no thank you.
I'm sure I can go either way. I can set up for a hearing, which would be this Friday at 1:30. Or if you want to agree to their consent terms that they offered you, you can do that too. I just need to know which one you're choosing.
I guess matter of fact, I'll go with the hearing. I just still want that to be heard. So yes, that'll work.
Okay. So we're at 1:30 here, everybody in person at the courthouse. We'll have the hearing.
Okay.
All right. So everybody come here, be ready to go at 1:30 and make sure that you have whatever receipts, whatever documents that you're going to bring those with you then. All right.
Okay.
So in person here at the courthouse. And that's going to be March the 14th.
Yes.
14th. And that'll be at 1:30 p.m. And we'll see everybody then.
Thank you.
Thank you, Your Honor.
On the record in the matter of People of the State of Michigan versus Kelly Tannery, file 244-176 SM. And let's have appearances, please.
Yeah, Mike Zakrzewski appearing for the people.
Frederick Jensen, I represent Ms. Tannery.
And Ms. Tannery, would you state your name?
Kelly Tannery.
Very good. This is a matter that's set for a plea. So Mr. Jensen, you want to explain to me your understanding?
Yes, Your Honor. Ms. Tannery will be pleading to disturbing the peace. And the original charge would be dismissed.
Is that a correct statement, Mr. Zakrzewski?
That's my understanding, Your Honor.
Ms. Tannery, is that your understanding?
Yes, Your Honor.
You understand you have a right to a trial, and if you went to trial, the prosecution would be obligated to prove that you're guilty beyond a reasonable doubt in each of the charges made against you?
Yes, Your Honor.
You understand if you make this plea here today, you're going to forego that trial. You're going to tell us you're guilty of disturbing the peace, and that's how the matter will be resolved. Is that your understanding, and is that your intention?
Yes, Your Honor.
Has anyone tried to frighten you or threaten you or intimidate you?
No, Your Honor.
Has anyone made promises to you that have not been placed on the record here today?
No, Your Honor.
Are you currently on probation or currently on parole for any other criminal convictions?
No, Your Honor.
The allegation indicates that this is an incident that occurred on October 19, 2024. Is that true?
Yes, Your Honor.
The allegation indicates that this incident took place in the city of Allegan, county of Allegan, and the state of Michigan. Is that also true?
Yes, Your Honor.
The allegation indicates that this incident involved in a disturbance of the peace that you created in an altercation with Heather Groenke. Is that true?
Yes, Your Honor.
What happened that created the disturbance of the peace?
Your Honor, me and Miss Gronke, she was my roommate. She told me my dad never loved me. My brother committed suicide last year, 4 years ago.
No. What happened that created the disturbance of the peace on this matter? It's not a matter of your life history.
No, we got into a fight earlier that day. She was eating a bunch of hot dogs. I called her fat cow and a pig, and then I just started hitting her in the head.
Okay, there we have it. Are you satisfied with the plea, Mr. Zakurzeki?
Yes, Your Honor.
Are you satisfied, Mr. Jensen?
Yes, Your Honor.
You provided me with a basis to accept the plea. I will do so. Mr. Zakurzeki?
Yes, Your Honor. We would leave this sentencing up to the discretion of the court.
Mr. Jensen?
Yes, Your Honor. Ms. Tannery is currently at Forest View Hospital. She doesn't have any place to live. The prior location, she was living in an AFC home, and she's no longer welcome there. At this point in time, she's asked for fines and costs, but she's also indicating she doesn't have any money, no ability for employment or income. So she's asking if there's any way to cut fines and costs down to the bare minimum. That would be appreciated.
What's our history?
With regard to Ms. Tannery, she's had one prior.
Oh, wait a minute. It was handed to me. I'm sorry. So this is the 1, 2, 3, 4, 5th. Okay. All right. Ms. Tannery, what do you have to say?
Your Honor, it would be greatly appreciated if fines and costs were cut down. And I've been working on keeping my hands to myself. I've been working on walking away since before I was leaving the group home. I got upset. I was walking away. People started to fight with me. I was walking away. I've been talking. I've been using my coping skills instead of putting hands on people. I almost got to a fight at the hospital, but I walked away and kept my hands to myself.
Well, but Ms. Tannery, this is in the last 6 years. We've had 5 incidents now that involve you acting out violently.
Yes, Your Honor.
So, I mean, you make it really hard for me. I mean, I would love to be able to say, okay, I'm going to, address this in a way that is going to be, not impose an inordinate financial burden on you, but what is it that we need to do to get your attention? Do we need to put you in jail?
No, Your Honor. What about, I was also thinking about this, Your Honor. When I get out of the hospital, if I could do anger management, I've been thinking about that. I think anger management classes would really help, like an anger management program and like a therapist, like a mental health therapist.
But you have people working with you on anger management at the home and at the hospital there too, don't you?
At the home, sir, it was more mental health than anger management. But when I get out of here, I was wondering if I could be, if there's an anger management program and if it's low cost or free. Your Honor, I can tell you this, as of that incident, there's been multiple opportunities for me to get in a fight, and I was walking away and keeping my hands to myself. I've been using my breathing techniques, and I've been using my coping skills.
Man, you didn't keep your hands to yourself when you were beating her. You just told me you were beating her. So
after that, I've been keeping my hands to myself.
Well, after that, I mean, yeah, that's like when you walk away after you beat someone up, that's not a matter of self-control. That's just having beat someone up.
Yes, Your Honor.
That's like, okay, well, all right. I'm not trying to mock you or anything. In any way, shape, or form. I'm just trying to wrestle with how do we address this in a way that we can get some meaningful changes in your behavior. If you have a complete inability to address this matter on a financial manner, I mean, it really leads my my toolkit pretty pretty sparse. I mean, I've got the opportunity to potentially put you in jail, I suppose.
Your
Well,
Honor,
what I'll do-
Your Honor, what opened my eyes was getting kicked out of that group home.
Well, you know what? You're going to get kicked out of groups when you beat people up.
Yes, Your Honor.
That's just, you can take that as take that as a mantra. If I beat someone up, I'm going to get kicked out. All right, I'm going to place you on probation for a period of 6 months.
Yes, Your Honor.
And there's a $180 oversight fee associated with that. Now, I might consider suspending that. I'm going to indicate that I'm going to place you on during that probation, that 6 months probation. I'm going to indicate that you're to provide you with either low or no cost anger management, but I'm going to suspend the sentence for 20 days in jail upon pending successful completion of that probation. I will also consider waiving fines and costs that are waivable. Not
Your
all of
Honor,
them
how
are.
am I supposed to complete probation when I have nowhere to live?
Well, I guess you're going to have to do it remotely from Forceview.
Yes, Your Honor.
I'm going to give you the number. The number for probation is 269-673-0359.
Thank you, Your Honor.
You'd probably have somewhere to live if you didn't keep attacking people in the group homes that you were living in. You know, just a little thought. And they keep referring to the hospital. She's currently in a psychiatric ward that she checked herself into right before the last court hearing that she was supposed to have. And I know this because when I was getting another case for an FTC that I was going to run, the lawyer literally just popped in and really quickly said, Your Honor, Miss Tannery isn't going to make it today. She's checked herself into a psych ward. And that was it. Like, there wasn't enough context to put it on. And I didn't even realize at the moment that it was the same person until I saw this. And then I was like, oh my gosh, yeah, it's the same girl. But yeah, jail probably would straighten her out a little. Just a little for a little while.
The fines are $200, state costs $50, court costs $200, crime victim right fee of $75. That with the probation is $705. You can take care of over the term of probation. But if you successfully complete that term of probation, I might consider dramatically reducing that by probably 80%.
Thank you, Your Honor.
I'm also sentencing you to 20 days in jail, as you probably guessed. And then I will suspend that pending successful completion of probation. So if you don't successfully complete probation, I'm going to have to send you to jail because we don't know what else to do to get through to you. All right?
Yes, Your Honor.
All right, you're all set. You can leave the court. Call probation, though. All right?
Yes, Your Honor. Thank you.
You're welcome. On the record, in the matter of People State of Michigan versus Beek, file 244452 FY. All right, Ms. Beek, can you hear us?
Yes, Your Honor.
All right, very good. Let's have appearances, please.
Micah Zakrzewski appearing on behalf of the people.
Kurt Richardson appearing on behalf of Selena Beek.
All right, Ms. Beek, state your name.
Selena Beek.
All right, Mr. Richardson, you want to state your understanding, please?
Your Honor, my understanding is Ms. Beek will be entering guilty pleas to domestic violence and reckless driving. The remainder will be dismissed.
Mr. Zakrzewski, is that your understanding?
Yes, Your Honor, that's my understanding. In addition, that the no contact would remain with the victim and the child being Charlie Ralph.
Did you file an amended complaint in this? I don't see one.
No, but I know we did motion to have the bond amended to include the child.
No, I'm saying, did you file an amended complaint? And the reason I'm asking that is you have an assault with a dangerous weapon. I don't know that I can consider reckless driving a lesser included of with an assault with a dangerous weapon.
Oh, yeah.
I think
The reason being that the dangerous weapon was the car, in fact, itself.
Well, I get that. I did read that part. Yeah, but I don't think I can consider that to be a lesser included. You know, I don't think reckless is a lesser included of that.
We agree to get amended.
I don't read it that way, at least. What was that, Mr. Richardson?
We'd certainly stipulate to receiving an amended complaint later for an added count for of reckless driving.
All right, can you get me that reckless amended complaint, Mr. Zekerzeki?
Yes, Your Honor.
It would be count 4 then. So, and I'll need a nollie pertaining to count 1 and 2 then.
Hey, Your Honor, I'll get our staff working on that right away.
Thank you. All right, Ms. Beek, you understand you have a right to a trial, and if you went to trial, the prosecution would be obligated to prove that you're guilty beyond a reasonable doubt of each of the charges made against you.
I understand.
You understand if you make a plea to counts 3 and 4, the prosecutor has agreed to dismiss the felony counts of 1 and 2, and that's how the matter will be resolved. There will be no trial of any kind. Is that your understanding, and is that your intention?
Yes, Your Honor.
Has anyone tried to frighten you or force you or intimidate you into doing this?
No, Your Honor.
Has anyone made any promises to you that I'm not aware of?
No, Your Honor.
Are you currently, are you currently on probation or parole for any other criminal convictions?
No, Your Honor.
The allegation here indicates that this is an incident that occurred on November 15, 2024. Does that sound correct to you?
Yes, Your Honor.
The allegation indicates that this incident took place in Cheshire Township of Allegan County in the state of Michigan. Does that sound correct?
Yes, Your Honor.
The allegation is that you did make an assault or assault and battery upon Ralph David Adams. Is that true?
Yes, Your Honor.
Who is Ralph David Adams?
My boyfriend.
And what did you do to him that constituted an assault or assault and battery?
I started swatting at him at a disagreement we had. I started swatting at him during a disagreement that we had.
All right. In regard to count 3, are you satisfied with the plea, Mr. Richardson?
Yes, Your Honor.
Mr. Zekerzeki?
Yes, Your Honor.
In regard to count 4, ma'am, it's indicated that you operated a motor vehicle in a reckless manner that constituted a danger, an intentionally operated a vehicle in a dangerous manner. Specifically, I presume, well, Mr. Zekerzeki, the basis of the reckless, what is the allegation you're going to be utilizing? I don't have that. I don't have that count in front of me, so that's.
The basis would be, let me see here.
Your Honor, the factual basis that she grabbed the wheel of the vehicle while they were traveling and attempted to make the car crash.
Ma'am, did you, while the vehicle was in operation, did you attempt to wrest control of the steering mechanism for the vehicle in a reckless manner?
No, Your Honor.
You did not?
Not while the vehicle was moving, no.
You wish to inquire, Mr. Richardson?
Yes, Your Honor. Ms. Beek, why don't you tell the court what you did that day as far as with the vehicle?
After we'd gotten disagreement and I'd started swatting at him, during the swatting and the arguing, we both believed that I had grabbed the wheel during our argument.
Was the car in motion when you were having that argument and you were swatting at him?
It may have been. It's possible. It's been like 3 months, so.
Ma'am, right now is the time for your plea. I can't take it may have been or guesswork. This is a criminal matter. And the people, Mr. Richardson, you want to inquire?
Ms. Beek, the car wound up in the ditch, right?
Yes.
And during the fight, you grabbed the steering wheel, correct?
Yes.
And Ralph indicated to the police at some point the vehicle may have been traveling 60 miles an hour on 42nd Street, correct?
Yes.
And it was your actions that caused the vehicle to wind up in the ditch, correct?
Correct.
Okay. No further questions.
Well, I find that interesting. I mean, thank you. I mean, certainly you've provided the basis for me to find it, to make a finding of reckless. I do find it rather curious, though, that with those circumstances, that there was some sort of confusion as to whether or not the vehicle was moving, if it was going 60 miles an hour. Mr. Zakarzeki, are we able to proceed to sentencing, or we need to set this matter for victim notice?
We would like to set this matter for sentencing. We're currently working on the amended complaint. I don't have the victim notice in front of me, so I'm not sure where the victim stands.
All right. I'm going to accept the plea. Upon presentation of the Nolly process, I will sign those dismissing the felony matters. We'll set both count 3 and 4 for sentencing with victim notice.
Thank you, Your Honor.
You're welcome.
She's getting really lucky with this plea. And how the heck does she not remember if the vehicle was moving or not when she was grabbing at the steering wheel and swatting at her boyfriend with their child in the car? Oh, yeah. Yeah.
Alina, you can disconnect. I'll let you know about sentencing.
All right. Thank you.
Thank you.
We have Mr. Beaky, or Beak, I should say. Is that you?
I'm the victim in the case, Your Honor.
Okay.
Ralph Adams.
You could have a seat right there. We will address that in a moment.
Thank you.
Trying to bring in Ms. Beek.
I got her in.
Attorney.
She's in. Yeah.
Okay.
Yep.
Very good. Thank you, Judge.
And who's her attorney?
Mr. Richardson.
Let's go on the record in the matter of the people state of Michigan versus Beak, file 244452 FY. Let's have appearances.
Mike Zakarzeki appearing on behalf of the people.
Kurt Richardson for Selena Beak.
Ma'am, state your name.
Selena Beak.
All right. We are here for sentencing. Mr. Zakarzeki, are you aware that we have a victim in the courtroom to make a statement?
Yes, I am aware of that, Your Honor, as well as I have a victim impact statement, which indicated they wanted it to be read. However, given that they're present in the court, I don't know if that needs to happen necessarily.
You want it read, or do you want to make a statement?
I'll make a statement.
All right. So, sir, state your name for the record and spell it for the record, please.
Mine?
Your name, yes.
Ralph Adams, RALPH ADAMS.
All right, very good. Please proceed, sir. Go ahead.
For the record, Selena was on medication prior to this. She was prescribed medication from her doctor. We noticed that there was an issue as far as the temper goes. So that's why we started trying to work with it. She did get counseling, which had started prior to the incident. We've never had an incident to where it was a physical altercation until the medication has started about 3 weeks into it. We both regret the decisions we made that day. As far as the no contact order goes, I was asking the courts to drop that. If not dropped between me and Mrs. Beak, if they're wanting to retain it because of my son that was in the vehicle that day, I asked that they retain it against him for his safety, but not for me.
Does that cover it? Or I don't want to cut you off.
I have a lot to say, but I don't know if it's gonna go anywhere. I haven't heard from any of the courts. I haven't heard from the district attorney, prosecuting attorney, anybody about this. I had to look it up online to even make it here today. I just kind of been left out of the loop about it all. And
Okay, did you, they do have an individual in the prosecutor's office that's that is identified as a victim coordinator.
I did do the victim's advocate, but still no one has reached out to me at all during this entire process. And all I'm looking for is just to see if we can get the no contact order dropped, so me and Selena can try to move on and put this behind us and try to move forward with our situation, relationship, whatever may come of it.
So, sir, let me take a moment. Are you finished?
Yes.
Because I don't want to cut
Yes,
you off. Let me take a moment to say thank you for coming forward and to share your perspective. It's I do appreciate it. I don't want you to feel like you're not being heard. What I do want you to perhaps consider and think about is that we get a significant number of cases involving domestic violent type circumstances where people try to cover for their partner or their significant other, or to minimize their behavior, and in that way to truly kind of perpetuate a problem by brushing it under the rug or saying, well, it's okay with me. And one of the things that oftentimes people do confuse in the circumstance of a domestic violence charge is they get upset when the prosecutor continues to press a case that they're saying, I don't want this case to go forward. Well, it's not the individual's case. It's the state's case. It's the state's case because the circumstances of domestic violence have a lot of far-reaching consequences. They're very dangerous cases for law enforcement to respond to. And there's other considerations, like in this circumstance, there's a child involved, so potentially child protective services. There's a number of different complicating factors.
Right.
That doesn't, I don't want to minimize the fact, though, that you took the effort and made the effort to be here today to share your concerns. And I want you to know that I hear them, and I will consider them. And I just don't want you to think that just because someone who is the victim in these types of cases says one thing, that automatically things are going to fall into place, because there are other considerations. I just want you to be aware of that. Okay.
Yes, Your Honor.
Okay. So thank you so much then for sharing. It does provide me some perspective. Mr. Zacker-Zeki, in regard to your recommendations for sentencing beyond what the Mr. Adams here has stated, what would you like to say?
Oh, we certainly, we don't object to amending. I mean, there wouldn't be a bond condition, I think, going forward, and that would seem to be the big concern. We don't have a problem with any kind of non-assaultive contact. As far as sentencing, we would leave it to the court's discretion.
Okay. Mr. Richardson, what would you like to say?
Thank you, Your Honor. Ms. Beek has accepted responsibility. She understands this was dangerous and a serious situation. She apologizes to the victim. We'd ask the court to consider probation in the matter. Thank you.
All right, ma'am, what do you have to say?
Your Honor, I'd just like to say that I accept full responsibility of my actions that day, and I would formally like to apologize to the victim for any added stress that I put on them. I would also, as well, would like to see or ask about the no contact order being lifted.
All right. I'm going to place you on probation for a period of 1 year. And the main basis of this, and I don't want you to hear this necessarily as more of as a punishment type factor. I want you to hear this as a tool, because we want to monitor how things are going to with whatever medications are involved, and also with anger management type concerns. I want to make sure that we are giving you the tools you need to find yourself to not find yourself in this circumstance again. To really, the purpose of the probation is to provide you with counseling, anger management, and or batterers counseling to enable you to learn how to deal with anger impulses and flashpoints, to be able to engage with individuals with whom you have a domestic relationship in a constructive and civil manner. Now, I will amend the no contact to be a non-assaultive contact going forward. So that part is going to be okay. But I really want you to consider the dangerousness of the actions here, especially with a vehicle. People don't ordinarily look upon vehicles as a dangerous weapon or such, but boy, it certainly can be. And you need to be very cognizant that there's an enormous number of deaths each year attributable to actions with motor vehicles. So that is not just a throwaway type of charge. That's a very significant charge. Yeah.
I understand that.
The plea on this matter originally was Mr. Zeki, I believe that was as to just the one. It was a plea to one count and a dismissal of the second count, correct? Let me just go back here. No, it's a dismissal of two counts, counts 1 and 2, and a plea to count 3. So the only real no contact order that is remaining in place right now is with Ralph Adams here, and that's what's being adjusted to no contact.
There's 2 counts you're sentencing her on today, 3 and 4.
Is there a 4th too?
There's domestic violence and
Reckless.
I'm
Or
sorry.
should be reckless.
and the felonies were dismissed.
Oh, look at that. How clever. All right. So I'll take care of, in regard to the no contact order, there is only, sure enough, there's my count 4. I apologize. In regard to the domestic violence, there is only the one victim in this matter. So that's the one we're adjusting. There's all when we dismissed the case pertaining to the child, that would have erased that no contact order. But even so, this no contact order is now not assault. You can have contact, it's just got to be civil in nature. In regard to count 3, then the fines will be $300, state costs $50, court costs $300. Crime victim right fee of $75. The probation oversight is $360. So that will be $1,085 for count 3. For count 4, we'll do fines of, I'm going to reduce the fines on that because we have the other one. So in regard to count 4, it will be fines of $100, state costs of $50, court costs of $100 for a total of $250. But understand with the with count 4, reckless, there's obviously going to be some Secretary of State ramifications as well, over which I have no control. And that will be then a total of $1,335 over the period of probation. All right, do you have the number for probation? Do you need me to give that to you, Mr. Richardson?
I have it, Your Honor.
All right, very good. Go ahead and call them to let them know you're on probation, but you are all set, man. You can leave the court. Once again, Mr. Adams, thank you for your attendance here today.
Thank you, Your Honor.
Welcome.
Thank you, Your Honor.
You're welcome.
Okay, calling case Robert Noor -25-07907. This is a swear to in the matter of Nina Ray Phillips. Detective, state your name for the record, please.
Detective Berenger with the Royal Oak Police Department.
Okay, raise your right hand. Solemnly swear and affirm the testimony you're about to give is true and accurate.
I do.
Okay, please state the facts as you know them in the Phillips matter.
All right. The facts of this case are summarized under Royal Oak Police Report number 25-7907. At approximately 1:45 a.m. on March 16th, officers were in the area of 5th and Center in downtown Royal Oak as the local bars were closing. Officers observed Phillips punch her boyfriend Tsunte Swift in the face, knocking him out. They went over and arrested her for domestic assault. And that's about it.
Thank you, Detective. Court finds the alleged crime was committed, probable cause to believe the defendant committed said offense. Court will sign and issue the complaint and warrant in this matter. Didn't see any notable CCH. Is there anything you
No,
have?
she has no criminal history. I have no issue with a PR bond.
Okay.
She was highly intoxicated, so
Yes, I know. Yep, noted that as
alcohol
well.
testing would be.
Absolutely. Thank you very much.
Yep.
All right. Here's the judge.
Okay. Calling case Robert Nora 25-07907. This is in the matter of Nina Ray Phillips. Counsel, again, appearance for the record.
Attorney Monica Sanford on behalf of Nina Phillips, waive from a reading, client stands mute.
Okay, Ms. Phillips, would you state your full name for the record, please?
Nina Ray Phillips.
Okay, counsel, would you like to proceed?
My client is 22 years old. She works at Millennium Family Dental as a dental assistant. She has no prior felonies, no prior misdemeanors. I would ask for a personal bond be granted at this time. She is not a flight risk and she will return for all further court proceedings, and she's not a threat to the community.
Thank you, counsel. Okay, the court will grant a bond in the amount of 1,000 personal recognizance bond in this matter. Ms. Phillips, you don't have any prior criminal history. The court is taking that into consideration, but nevertheless, there was a alcohol involved in this matter, so the court will also be ordering that you refrain from using alcohol, any form of THC, marijuana, illegal drugs, or abusing any medication. You will be required to test 2 times a week for alcohol and drugs. Will be ETG testing. You will not have any direct or indirect contact with the complaining witness in this matter. That is Tasante Swift. No contact with that individual. You will not assault, beat, molest, or in any way verbally harass, intimidate, or threaten any potential witnesses in this matter. Personally appear for all court appearances. Do not leave the state of Michigan without permission of the court. And if you should change your address, immediately notify the court in writing of that. You will not possess any firearms or other dangerous weapons. And you must contact pretrial services within 24 hours of your release. Pick up no new criminal offenses while you're out on bond. And court-appointed counsel is granted in this matter. You will have an attorney representing you at your next court date. Do you understand your bond conditions, ma'am?
Yes, I do.
And state your full name again, please.
Nina Ray Phillips.
Okay. You're all set. Good luck to you. Thank you, counsel. What was the other file you had?
So the other one is a disorderly. He was issued a citation that I would like to get him arraigned on.
Oh, yeah. No swear to. That is on, is that on Swift or is that on the one we just had?
Yep, that is on Swift.
Okay, yes, I have that file on Swift. Give me 1 second here. I don't think. That was a ticket, so that's not, you don't have a warrant, and that was a ticket, right?
Correct. Yep.
Okay, I'm all set on, I'll be set on, go ahead.
I'm gonna ask for some sort of a cash bond on this one. This individual is actually the victim of the in custody DV. He's the one that got punched in the face. He came back.
Correct.
He came back to the station yelling at the front desk for 20 some minutes before running out of the station and into traffic. He does have 2 fail to appear warrants right now. One for disorderly conduct and another one for being drunk, I believe. Maybe it's just drunk and disorderly.
Yeah, I think that's out of Fraser and Detroit. I believe he has a couple.
Yeah, and then I would ask for no contact with the Phillips, if that's possible, because I feel like he's gonna try to continue contacting her once he's released, which would be a violation of her bond.
Okay, thank you very much.
Yep.
All right.
I'll go see if they if the attorney's done with everyone.
Yep, I've got them in the breakout room, so they'll come back. She'll come back in. The attorney will come back in, I'm sure, when they're done.
They are, I think they're booking Swift right now because he was too uncooperative to book when they first brought him in. So she hasn't met with him yet.
Okay.
Please let me. Gonna pop up. There he is. Hey, Judge, please, Judge. Good, please. I'm sorry.
Yeah, I think the Novi, the attorney is still in the other room. I don't know, I suspect she may be speaking with some other parties yet, so she's not available yet to come into the room.
Okay.
We'll check and see. We'll check and see if she's interviewing other people in the room or she's ready to come in. So hold on a second. Yeah, she's still talking to people, so we're gonna hold off for a minute, okay? And we'll get them all through at the same time. Okay, thank you.
So do I gotta wait? You're gonna talk to somebody else? Okay.
Are we ready?
We're ready. I think the attorney just came in. She said she was ready. We assumed she was interviewing others, but she's ready, so we can get started.
We gotta meet with the judge right now.
Please call my grandma. You're not saying a word.
No, because we have to focus on this right now. Oh, your grandma. We gotta get through this first.
What? Thank you so much. Thank you so much. Thank you.
Sir, at the jail, what is your name?
Asante Swift. Asante Swift.
Thank you. Calling case Tom King, Tom 25, Robert Ocean 01486 in the matter of Tashanti Swift. Counsel appearance for the record, please.
Attorney Monique Sanford, P6215 on behalf of Tashanti Swift.
Okay, sir, at the jail, state your name again, please.
Asante Swift.
Okay. Counsel, how would you like to proceed?
Wade, former reading client stands mute.
Will indicate that your client stands mute in this matter. Would you like to address bond?
Yes, Your Honor. My client is 23 years old, graduated from Warrenwood Tower High School, lives with his grandparents. He works at his grandparents' church. I do believe a personal bond is appropriate in this matter and would ask that he be given a personal.
Okay.
I do not believe he has any prior felonies or misdemeanors.
That's correct, counsel. There's another individual that's just affiliated with this in another case number that we're going to get to shortly. The defendant in this matter, the allegations are he did run out into the road and put others at risk, and there's a lot of other matters taking place that the court's concerned with. The court's going to set a bond in the amount of 700 cash surety. No 10% on that matter, just for general safety of the public based upon the defendant's alleged actions in this matter. The court will also have some other conditions, sir. You will not assault, beat, molest, in any way, verbally harass, intimidate any potential witnesses in this matter. Personally, sir, appear for all your court appearances. Do not leave the state of Michigan without permission of the court, and immediately notify the court in writing of any change of address or phone number. Will not possess any firearms or other dangerous weapons. You shall refrain from using alcohol, any form of THC, marijuana, illegal drugs, or abusing any medication. The court will be requiring you, as alcohol may have been a factor in this, the court is requiring that you test 2 times a week for alcohol and drugs, ETG testing. Pick up no new criminal offenses while you're out on bond. And also no contact with Nina Phillips. No contact with Nina Phillips. I believe you may have been in a possible dating relationship with that individual. The court has granted court-appointed counsel on your behalf, so you will have an attorney representing you at your next court date, which is going to be a pretrial date. I don't have that date in front of me, but you will be provided with that date. Sir, do you understand your bond conditions in this file?
I do.
I didn't hear, you have to speak up a little bit louder.
Yes, I do.
Okay, you're all set then. Thank you very much. Good luck to you, okay?
I'm gonna bring the iPad to Ms. Phillips next.
Okay, thank you.
So we're supposed to talk to her? Yeah. Can I get a real phone to call my brother? I'll ask. They want to arrange for you.
The deputy is actually on his way to Miss Phillips now with the iPad. I had to put him out of order. Otherwise, it didn't make any sense as to why he, charged the police station and, spent 20 minutes yelling at officers before running into traffic. And yeah, it wouldn't have made any sense if I ran his situation first. And I got some good bandit cuddles there at the end. Nice couple of minutes of snuggles. Sorry, we were chatting in the chat, and so I'm looking for ones, case related, but I don't know if any exist. But I am actually pretty tired, and I think I'm gonna get some sleep because of that. Bandit cuddles are the best. I love my snuggles. I love snuggle time. You did not kidnap the chat. You are welcome to take them out for ice cream anytime. Don't be. You're fine, Uncle Charlie. I love you guys so much. Yeah, exactly. I think I should. I really think I should. All right, guys. Thank you so much for coming out and being with me tonight. Be safe, be well, sleep sweet, and much love.